Okay, it is Tuesday, October 14th, and this is Section 1 of Admiralty Law. We're going to talk about limitation of liability today, and on the board over to my right, not behind me, there is the article that was written by Jim Mercante that very succinctly describes limitation of liability and its history. And if you look at the third column, lower right there on the screen, you'll see that this was a statute that was enacted back in 1851, almost 200 years ago. What was the idea? Well, the idea was that other nations had limitation statutes, and their vessels might be overseas and might do some damage to bridges or other structures or cause some kind of damage to something somewhere. And the idea was to protect American shipping. American shipping needed something to protect vessels from extremely high liability. So the idea behind the statute, which still exists today, is that in a case where a vessel causes some harm, the liability as to all potential claimants can be limited to the value of the vessel itself. And that means the value of the vessel itself after the problem. So it could be very low if the vessel sinks, right? But, if it's still in operation, in today's dollars, the vessel might be worth some millions of dollars, depending on the size of the vessel, etc. But it's still around. There have been some changes to the limitation statute over the years, and every so often there's a public outcry for more changes. In this article, one of the things that's mentioned is Deepwater Horizon, because there was some applicability of the limitation statute as far as that rig that caused the pollution, and so that's mentioned in here. There's been another amendment relating to small vessels since this article was written, but none of that is really relevant to what we're talking about here. The basic principle here is that if the vessel causes some tort, hits a bridge or people are injured or whatever, under the statute, assuming the statute applies, the claimants who have, some kind of a claim against the vessel for that tort or against the owners of the vessel, the payments can be limited to the value of the vessel. Now, you'll see in this article that if it's a passenger ship, there's an additional fund. But that's something that was added later. The original plan was just value of the vessel. And a lot of times, it's not a passenger vessel, so there's still not any additional fund. One of the most important things to remember that's not in this article at all, or at least not very well developed in this article, is that the limitation statute doesn't actually provide for the federal courts to have jurisdiction over the action. And that's a little odd. We have to examine how that works. Remember, way back in Module 1, I said there are certain things that only federal courts can hear. State courts can't hear them. It depends on the remedy you're seeking. So I said, if you're suing a vessel in rem, or if you're enforcing a maritime lien, it can only be in federal courts. State courts can't do it. Well, this is another one that's only available in federal court. And yet, maybe you can't get into federal court. So how does that work? Well, the idea is when this was enacted, it was almost a given that any of these limitation cases would be cases involving a big ship on navigable waters doing traditional maritime activity, and there would be no doubt that there was federal jurisdiction. Remember, federal subject matter jurisdiction in Admiralty subdivides into contract jurisdiction and tort jurisdiction. Here we're talking about federal tort jurisdiction in Admiralty. And it's a little complex whether or not federal tort jurisdiction exists. Just because you're bringing a limitation action doesn't mean federal tort jurisdiction exists. Up until relatively recently, it probably wouldn't have been anything you had to worry about, because most of these cases involved big ships out on navigable waters, hitting bridges, doing traditional commerce, maritime commerce, all the things that would give federal tort jurisdiction to the case, and there would be no doubt. But the very author of this article, Jim Mercante, has found himself a niche, and he's not the only one these days, but sometimes this limitation stuff is brought in the context of maritime cases where it's not clear that there's maritime tort jurisdiction. For example, the case we're going to read, in re petition of Bruce Germain, occurred up on a waterway, Lake Oneida, upstate New York, and it was a recreational vessel. Probably the vessel wasn't worth more than $25,000, so limitation would have been very good for the owner. But it was in shallow water. Lake Oneida is a navigable waterway, but it was far away from the navigable part, and they were sitting at anchor, and they weren't doing any commercial maritime activity at all. And bottom line is the injury occurred because one of the passengers jumped from a high point on the vessel and did a nice dive into shallow water and broke his neck. He decided to dive from 20 feet into 5 feet of water, something like that, which is an easy way to break your neck and become a quadriplegic, which is exactly what he did. And then, as I said, limitation of liability does not of itself, the statute does not of itself provide that there is federal jurisdiction. Again, it can only be brought in federal court, but in order to get there, you have to have a basis to be there other than the limitation action itself. Got it? Does that make sense? So there's a kind of a catch-22, maybe that's not the best analogy, but you got to be in federal court to use the limitation statute, but the limitation statute doesn't give you a ticket into federal court. You have to have a jurisdictional basis to be there, and generally speaking, that is whether or not there's admiralty tort jurisdiction, because these always concern torts, right? It's always an injury, damage to a bridge, injury to a person or more than one person, sometimes many persons, many people. But the bottom line is that in order to be in federal court to avail yourself of this remedy, limitation, you need a jurisdictional basis to be there, and that jurisdictional basis is the one we're going to explore in the case. So this little bit on limitation is really a springboard to some aspects of admiralty tort jurisdiction that relate to the very case we're going to read. And you'll see that in the case itself, the whole aspect of the limitation proceeding, it's not really central. You're aware that when you read the case that that's why it's being discussed, but there's not much discussion of the limitation statute itself. The discussion is really about whether or not there's admiralty tort jurisdiction so that the limitation action can either be entertained or not. And as I said, the district court, not the case you're going to read, but the opinion below, said no, there's no admiralty tort jurisdiction, limitation action dismissed. Mercante appealed. Mercante also happens to be the author of this article, but he's also counsel on that case we're going to read. He appealed and he won. And the Second Circuit said, yes, there is admiralty tort jurisdiction. So they reversed the lower court and they went into a very detailed analysis of the whole history of how admiralty tort jurisdiction got so complex, because it used to be pretty simple. And in fact, oddly, maybe not oddly, maybe reasonably, Mercante, as an advocate in that case, said, I'd like this court to just make it back to the way it used to be, and simple. If it's on a vessel in navigable waterways, there's admiralty tort jurisdiction. What did the Second Circuit say? They said, we can't do that, because the Supreme Court is the one who made it as complex as it is. If you want them to change it back to the simple test, you got to go to them. And of course, he had won the Second Circuit case, so he wasn't going to petition for cert, for a case he had won. And so the Supreme Court has not revisited the rather complex mess of what admiralty tort jurisdiction requires. But it's not that complex. It's really, it's really divided into two words that, and I used these already in the module 1, but they don't use the words in the case. But the Latin words are locus and nexus. Locus means place. Was it on navigable waters? And nexus means connection. And was there a connection of the activity to traditional maritime activity? And then it also subdivides, which you're going to see when you read the case, to whether the incident had a risk of creating, or whether the incident had a potential to disrupt maritime commerce. So that nexus one, the connection one, subdivides into two parts, and that's where it actually gets interesting. That's where I had come up with some interesting arguments on the second case, the one that's still a real case that's still in litigation. And the motion to dismiss has not yet been made, but the motion to dismiss would be based on the idea that there is no admiralty tort jurisdiction based on that second subdivided part, whether or not there was a risk to maritime commerce. But we're not going to explore that until we've read the case, and then we'll use the second case as a sort of hypothetical, but I will tell you it's based on a real case. And that's what I did last semester. It was very fruitful, very interesting. So I'd like to do that. It's a little more challenging this semester because I've got 2 sections to discuss it with, and you really do need to catch up on the underlying law by reading the case before we can get to that. But this is a springboard. Limitation of liability is a springboard to a lot of that other stuff, because believe it or not, a lot of cases, including the collision case we're going to do next module, actually get into federal court here in the United States because of limitation proceedings. Once the court has a limitation action, assuming it retains jurisdiction, it can decide all kinds of issues. So we're going to be reading about a collision case that I like to use, because there's an article I wrote about it years ago that lays out all the facts very carefully. It actually involved 3 vessels in fog in the English Channel. None of them were American flag, and yet the judge in the United States District Court decided issues of liability and fault as to all 3. How did that come into the federal court in the U.S.? Limitation proceeding. And once it was in, the judge gets to decide all these other issues involving the collision itself and who was at fault. So limitation sometimes becomes a real entry point. For example, a lot of Titanic litigation was brought in the U.S. on limitation actions way back in the turn of just after the turn of the 20th century, I guess it was 1912, the collision occurred, allusion, I guess. You hit an iceberg, vessel hit an iceberg. And then, interestingly, the White Star Lines, in their limitation proceeding, which went all the way up to U.S. Supreme Court, they used 2 firms in New York. Why did they use 2 firms? Because they were the 2 big admiralty firms. The patriarchs were C.C. Burlingham and J. Parker Carlin. One was with one firm, one was another. They hired both of them so they wouldn't have the other one on the other side. These were like the 2 premier maritime lawyers at an early 20th century. I actually ended up working for both firms, you know, the successor firms, Burlingham Underwood and Carlin Campbell and Keating. I had this kind of interesting scenario where I was working for the 2 firms. Nobody else I know ever worked for those 2 firms. They were both on their way downhill by the time I got there. They were like, you know, they were big not mega firms, but they were big admiralty firms. They're kind of dying as the 21st century got started, and they both went under. And I worked for one for a while, and then I worked for the other. The first one, Burlingham, we actually had a picture in the library of the iceberg that the Titanic hit, because part of the firm's history was doing that. But anyway, bottom line is, the whole Titanic litigation that got to the U.S. was because they did a limitation proceeding here on behalf of White Star Lines, the owner, and all they obviously didn't have the Titanic, but they had a lifeboat, you know, and that was enough to have something in the jurisdiction to hang their hat on for the limitation proceeding. So sometimes the law, you know, you say common sense. It isn't always common sense. I mean, it isn't common sense that you would get a limitation proceeding based on the presence of a lifeboat in the jurisdiction of a vessel that went down in the middle of the Atlantic, but you do. So sometimes it's not so much common sense. I mean, a lot of law is common sense, but a lot of admiralty is a little wacky. Sometimes it's not so much common sense. For example, when we get to cargo, is it common sense that it should be a defense if you have a collision and destroy the cargo because you messed up and had a collision, that actually defends the carrier and you're not liable? I mean, isn't the carrier's job not to have collisions, you know? But if you have a collision, you're not liable for all the cargo you damaged by having a collision, even if the collision was totally based on your own negligence. Yet that's the case. It's not obviously common sense. You know, the law sometimes goes counter to common sense. And there are many instances in the law where it isn't as common sense as you would hope or think. And it's paradoxical. But anyway, certainly in limitation, there's some oddities. One is the jurisdictional one I mentioned. You know, you'd think common sense. Oh, well, if you have to be in federal court for a limitation proceeding, certainly if you want to bring a limitation proceeding, you ought to get to be in federal court. But actually, no. You know, you have to prove that you're available, that federal court is available to you, that there's a jurisdictional basis to be there if you want a limitation action. And so that's what this next case is about. I haven't assigned a final date for it. It's been lurking in the modules supplement. The dates have been pushed forward. I will upload a module supplement version 5 within the next day or so, and we will adjust our schedule accordingly. But really, I mean, it's not the kind of case you want to just skim through and read slowly, read quickly. So try to start looking at it if you haven't already now or soon. It's been on there for a long time. There will come a day when I'm going to want to discuss it, and actually we'll not video record, we'll actually call on people and do the law school thing. So it would be better if you're somewhat prepared and don't have to say, I have no idea what the case is because I haven't even looked at it. It's just one little law school experience in this whole course. Just one little taste of reading a case and discussing it in class. And you'll get out of it what you put into it, but if you don't put anything into it, you won't really learn anything from the experience. And it's worth reading a case and trying to figure out what it's saying, and then making arguments about how the law that it's stating can either be extended to a new scenario or not. So we're going to try that. And again, the linchpin that brings us into that case is limitation of liability, although the case doesn't really focus on it. It focuses more on admiralty tort jurisdiction. But the reason it has to is because the limitation action depends on there being admiralty tort jurisdiction. Without admiralty tort jurisdiction, you can't bring the limitation action in federal court, and without being able to get in federal court, you can't bring the limitation action. You simply cannot do it in state courts. State courts are not able to bring limitation action. So you got to be in federal court, but to be in federal court, you have to have admiralty tort jurisdiction. Again, cases like the Titanic or this collision we're going to talk about, there's clearly admiralty tort jurisdiction. These are ships out on the high seas, doing things that ships do, so there's no doubt there's admiralty tort jurisdiction. But when you have these little cases involving like a recreational vessel in some inland lake upstate, or some dredging by the edge of Cold Spring Harbor and the guy falls when he's on land because the scaffold collapses, maybe there is, maybe there isn't, and that's where you get into these nuances. And those are the two things we're going to examine, those sets of facts. One is the case that we're going to read where it was a recreational vessel and the guy took a dive, and the hypothetical case, which is a real case, is the one where the guy fell from a scaffold that lost its footing because of the dredging that had been done by a marine operation some days before.